Birthright citizenship in the United States, as enshrined in the 14th Amendment of the Constitution, grants citizenship to anyone born on U.S. soil, regardless of the parent's nationality. This foundational principle has been a cornerstone of American identity and immigration policy since its inception. Understanding its history, implications, and contemporary debates sheds light on the complexities of citizenship in a diverse and evolving society. The 14th Amendment, ratified in 1868, was a response to the aftermath of the Civil War and aimed to secure the rights of newly freed slaves. Its citizenship clause declares that all persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. This clause was intended to overturn the Dred Scott v. Sanford decision, which denied citizenship to African Americans, and establish a broad definition of citizenship based on birth rather than ancestry. Birthright citizenship serves several purposes. First and foremost, it upholds the principle of equality by granting citizenship to all individuals born within the nation's borders, regardless of their parents' status. This inclusivity reflects the American commitment to equal opportunity and individual rights. Additionally, birthright citizenship fosters social cohesion by integrating diverse populations into the fabric of society from birth, promoting a sense of belonging and allegiance to the nation. The concept of birthright citizenship has faced challenges and controversies throughout history. In the late 19th and early 20th centuries, nativist sentiments led to calls for restrictions on immigration and efforts to exclude certain groups from citizenship, including Chinese immigrants and their descendants. However, the Supreme Court consistently upheld the principle of birthright citizenship as a fundamental constitutional right. In recent years, birthright citizenship has become a focal point of debates surrounding immigration and citizenship policy. Critics argue that it incentivizes so-called birth tourism, whereby foreign nationals travel to the United States to give birth for the purpose of securing citizenship for their children. While there is no official data on the extent of birth tourism, anecdotal evidence suggests that it is a growing phenomenon, particularly among affluent individuals from countries with more restrictive citizenship laws. Tourism childbirth, also known as birth tourism or maternity tourism, refers to the practice of traveling to another country for the purpose of giving birth and obtaining citizenship for the child. In the context of the United States, tourism childbirth typically involves foreign nationals, often from countries with more limited citizenship rights, coming to the U.S. to give birth to ensure that their child receives American citizenship. The motivations behind tourism childbirth are varied and complex. For some parents, obtaining U.S. citizenship for their child may provide access to better educational and economic opportunities in the future. Others may view it as a form of insurance against political instability or persecution in their home countries. Additionally, the U.S. citizenship of their child may facilitate family reunification or serve as a pathway to residency and eventually citizenship for the parents themselves. Tourism childbirth raises legal and ethical questions regarding the integrity of citizenship and the fairness of the immigration system. Critics argue that it exploits a loophole in U.S. immigration law and undermines the principles of citizenship by birthplace. They contend that citizenship should be earned through meaningful connections to the country, such as residency or allegiance, rather than simply by accident of birth. Efforts to address tourism childbirth have been limited and contentious. Some lawmakers have proposed legislation to restrict or abolish birthright citizenship, either by amending the Constitution or reinterpreting the Citizenship Clause. However, such proposals face significant legal and political hurdles, as any change to the Constitution requires a two-thirds majority vote in both houses of Congress and ratification by three-fourths of the states. In the absence of legislative action, the issue of tourism childbirth remains a topic of debate and concern. Proponents of birthright citizenship argue that it is a fundamental principle of American democracy and a reflection of the nation's commitment to equality and inclusion. They contend that efforts to restrict or eliminate birthright citizenship would undermine these principles and create a two-tiered system of citizenship based on ancestry or wealth. Ultimately, the question of birthright citizenship and tourism childbirth raises fundamental questions about the nature of citizenship, identity, and belonging in an increasingly interconnected world. As the United States grapples with these issues, it must balance competing interests and values while upholding its commitment to the principles of equality and justice for all. What do you think? Leave your comment in the comments section. Don't forget to like, share, subscribe and click the notification bell. Bye.